Ladies and gentlemen, welcome back to the Indie Zone. My name is Kathy. This is an update on matters concerning the federal case styled as Goncalves et al. Versus Washington State University. As we had previously reported, the parties had filed a joint stipulation seeking a protective order concerning matters relative to discovery. And on the 29th of May 2026, the federal court, Judge Evanson, denied that motion for a protective order on the grounds that it did not comport with Local Rule 26C2, which required that if a party, or in this case parties, submit such a motion or a stipulation for this type of protective order, that if they deviate from the protective order that has been approved in this district, that they have to redline it, meaning they need to highlight all areas for the judge so it is clear and unambiguous of what additional words, terms, sentences are added or are taken from the standard motion for protective order. We note on the docket today, the 1st of June 2026, that the parties have refiled the stipulation with the proposed order that appears to be redlined. You'll recall the judge did not deny the prior motion with prejudice, meaning that would have been it. There would be no further opportunities for the parties to resubmit. So therefore, they have resubmitted, and we will be providing some follow-up content to go over what the changes are at this time, and also, once the court renders a decision, what that is. The other item on the docket today, minute entry. This is from the proceedings that were held today before District Court Judge Kimberly K. Evanson, who has been presiding over this case ever since it was removed by the defendants from state to federal court in January of this year. And according to these minutes that appear to have been taken down by the deputy clerk, D. Staples, that appearances were made for counsel for both sides, and that the time of the hearing was 10 o'clock a.m. on the 1st. This was a Zoom status conference, and there were notes here that indicate that the court and counsel discussed trial scheduling. You'll recall that the parties had asked for a June 1st potential trial date for 2027. They stated in their joint status report that was filed last week, they wanted a 20-day jury trial commencing on June 1st, 2027. So it appears that that was discussed. The court deputy will issue a September 2027 trial schedule. So it appears that this matter is going to be set for final jury trial in the fall, not in the summer of 2027. Discovery matters, any concerns about discovery in the case are going to be referred to the magistrate. That is Judge Peterson. You'll recall that in the joint scheduling report, we had previously stated that the parties refused jurisdiction of the magistrate for any matters in the case. The judge has now stated that at least any discovery disputes, such as motions to compel discovery and potentially this stipulation here that was just filed, because it deals with discovery as well, will be handled by Magistrate Judge Peterson. And then the hearing was concluded. We will look for the court's scheduling order. Remember, as we have said before, what was in the scheduling report by the parties were recommendations. Whatever the judge has in this scheduling order, such as cutoff for discovery, cutoff for when any parties can be added to the case, cutoff for example, motions in limine, any pretrial motions of significance, such as motions for summary judgment. There will be deadlines associated with that, we anticipate, in this forthcoming scheduling order. So please stay tuned to the Indie Zone for further details. Until next time, this is Kathy. Thank you for joining us here today.